Welcome to Veranda IAS. In today's current affairs session, in the subject International Relations, we will be dealing with the topic General Data Protection Regulation. So, the learning objective of today's LU is to explain the General Data Protection Regulation, that is GDPR, and to examine the GDPR in news, and also to discuss about the background of this GDPR, and also to analyze the data protection principles used under GDPR. We will be also outlining the data protection laws which is in India. So, to moving on, let's discuss about this GDPR. It is an European Union and the European Economic Area regulation on data protection and privacy. Further, the GDPR's main goal is to give peoples more control and rights over their personal data while also making the regulatory environment for multinational businesses easier to navigate. So, what is actually GDPR? So, in this current world, current sense, what is most valuable thing? It is the data. So, everywhere what we see is the collection of data. So, a people's privacy is very much needed. So, for an livelihood. So, hence for safeguarding that privacy, the EU had come up with this GDPR. So, that is why we are discussing about GDPR. So, why this it is in news? We will see that Ministry of Electronics and Information Technology (METI) of India has submitted a notification to WhatsApp in May 2021 requesting to reverse a contentious amendment to its privacy policy that could jeopardize Indian data protection. So, the METI had given an sought an explanation, submitted a notification to WhatsApp because WhatsApp has updated its privacy policy, which may actually affect the privacy policy, the private policy of the Indian citizens. So, that is why the ministry had sent such a notification to WhatsApp. So, the users will no longer be able to prevent WhatsApp from exchanging data such as location and phone number with its parent Facebook unless they have removed their accounts entirely according to WhatsApp's new privacy policy. So, what is the new privacy policy? Because we all know that the Facebook is the parent company of WhatsApp. So, the WhatsApp can, without the permission of the user, can share the data of a particular user of an WhatsApp, the location, the phone number, and what are the details which is present in the WhatsApp, it can share with its parent company, that is Facebook. So, Facebook can use the data for any other purposes. In such a way, the privacy of a person is actually violated. So, that is why the ministry has asked for explanation to WhatsApp in regarding this policy. According to the government, the messaging application treats Indian users differently when compared to the European users when it comes to opting out of the new privacy policy. So, the European Union, so the users in the European Union countries, they had the option of voluntarily abiding by this privacy policy of WhatsApp. But in case of India, it is mandatory. So, every user of an India, they should give mandatory agree to the new policy, new privacy policy, whereas in Europe it is voluntary nation. That is why this the METI, the Ministry of Information, Electronics and Information Technology had the government had found that Indians were treated in a different way when compared to Europeans. That is why the issue has been escalating. So, let us discuss about the GDPR. So, what is the GDPR? So, the right to privacy is included in 1950s European Convention on Human Rights, which declares that everyone has the right to respect for his or her private family life, his or her home, and his or her correspondence. The European Union has tried to preserve this right through law on this basis. So, this is actually created by European Union for the European people, so that to safeguard the rights and privacy of the peoples who living in those countries. Further, it enacted the European Data Protection Directive in 1995, setting baseline data privacy and security standards on which member states developed their own implementing legislations. The GDPR became effective from the year 2016 following European Parliament approval, and all businesses were required to comply by 25th May 2018. So, from 25th May 2018, all the business firms, they must comply with the GDPR. That is, they must keep the privacy details of the users safely. So that is has been in effect from 2018. So further, let's see about the data protection under the GDPR. So what are the basics data which need to be provided, which need to be protected under GDPR? So what are the principles under the GDPR? We will see about this. So lawfulness, fairness and transparency. So these are some of the principles of GDPR which is actually proposed by the, which has been implemented by the European Union. So lawfulness, fairness and transparency. For the data subject to have confidence in the processing, it must be legitimate, fair and transparent. So anything, so for example, if any company coming up with a privacy policy, it should be abiding with the law, it should be transparent, it should focus, it should showcase what are the things which need to be done, which can be done with regarding to the privacy policy. So everything and fairness, everything should be considered. Further, the purpose limitation. So the process data for the legitimate reasons that were expressly stated to the data subject when the data was first gathered. So for what purpose this data was actually collected? So that purpose should be told. So according to the principles of GDPR. Further, the data minimization. Only the data that is absolutely essential for the purposes mentioned should be collected and processed. For example, if according to a privacy policy, if a company, firm requests only location of a people, it should obtain only location of the people. It should not obtain any other information such as mobile numbers or any other, the gender, the age, any other information they should not take into consideration. So that is why data minimization, it is one of the principles. Further, accuracy maintains the accuracy and timelessness of the personal data. For example, if a data is collected for one particular thing, for example, anything for one particular purposes, after the purpose is completed, that data should have been deleted. So that was actually given with regarding to the principle of accuracy. After that, the data should be deleted. Further, you see that storage limitations. Only preserve personally identifying information for as long as it's required for the specific reasons which it was actually collected. Also, the integrity and confidentiality. Processing must be carried out in a manner that ensures that the proper levels of security, integrity and confidentiality, example by using encryption. So this data should be integrity and confidentiality. So for example, any data is collected, it should be confidentially kept with themselves. It should not leak to any other party such as the third parties. Further, accountability. The data controller is responsible for demonstrating to the supervisory authority that GDPR compliance with all of this criteria has occurred. So there should be accountable data managing authorities to which the data compliance, the data collecting firms must be accompanied with. Further, let's see about, so these things we have seen before are the GDPR, which is the protection laws of the European Union. So data protection laws of European Union. So let's talk about some of the data protection laws in India. So we have seen how this GDPR has evolved in Europe. In India too, we have certain kind of constitutional provision itself with regarding to the safeguarding of public privacy. So for example, we have Article 21, which deals about the right to life, means right to privacy. So let's talk about it in detail. So introduction to the Personal Data Protection Bill. So Mr. Ravi Shankar Prasad, the Indian Ministers of Electronics and Information Technology, introduced the Personal Data Protection Bill 2019 in India's Lok Sabha on 11th December 2019. So the minister had introduced a certain kind of bill, that is the Data Protection Bill of 2019, in an idea such as the GDPR. India too had its own version, that is the Data Protection Bill. So it has the protection of individuals' personal data. So the bills seek to protect individuals' personal data by, among other things, establishing a data protection authority to monitor the protection of such data. So in lines of GDPR, we too will be having a data protection authority through which the business firms will be responsible to. Then applicability. So the bill regulates the processing of personal data by the following entities. So the bill covers what are the agencies? It covers the government, the Indian incorporated corporations, and the foreign firms dealing with the personal data of Indian citizens. So our government has the major number of records with regarding to its citizens. For example, we have Aadhaar. In Aadhaar, we have many biometric informations and other information of individual persons. In such case, the government must keep it so privately, and also the Indian incorporated company, any other companies which is working in India, which is based in India, they must abide by this bill and abide by these laws. And also the foreign firms, that is the firms which is working onshore. So they, such as the Facebook, the WhatsApp, so everything they should be complying by these provisions. Further, the bill also has the obligation of a data fiduciary. So all data fiduciary are required to adopt a specific transparency. We see these provisions in GDPR and accountability measures, including implementing security protections such as data encryption and avoiding data abuse. So any data which will be shared to these these fiduciaries, they must be protected safely so that there should be no leakage of data from these fiduciaries. Also, establishing grievance redressal systems to handle individual concerns. So if any concerns, they need to be addressed with regarding to the grievance redressal mechanisms. Further, the rights of the individual. The bill establishes some individual rights or data principle. So these rights include the ability to obtain confirmation from the fiduciary that their personal data has been processed. So before any data is being collected, so the individual must be asked so that the data can be shared. Also, request of correction of inaccurate, incomplete and out of date personal data. So the data which can be shared, it should be up to date. Also, have personal data transfer to another data fiduciary in certain circumstances and restrict a fiduciary from continuing to disclose their personal data if it is no longer necessary or a consent has been withdrawn. So if you are giving some of your details, for example, if you are opening your account in FB, so you are actually producing some of the details to this platform. After you remove your account, this organization should not use your information. They should actually delete the information as soon as you delete your account. So that is the thing which was actually employed in this point. Then further, the grounds of processing of personal data. So the bill permits fiduciaries to process data only with the individual's consent. However, certain conditions allow for the processing of personal data without consent. So who has this discretion? It is actually the government. So government can usually use this loophole to have the data of the privacy of the individuals for security purpose or any other purposes. Then social media intermediaries. So the bill describes the social media intermediaries as a middleman that facilitate online contact between the users and the information sharing. Further, let's see about the data protection authority. So what is the authority with the bill was actually referring to? So the bill established a data protection authority that has the authority to safeguard people's interest, to prevent personal data misuse, to ensure compliance in the bill. It shall be chaired by a chairperson and comprised of 6 members. So there will be a chairperson along with 6 other members. So they will be actually having an experience in IT for about 10 years. See, it shall be chaired by a chairperson comprised of 6 members having at least 10 years of experience in data security and information technology. the authority's orders may be appealed by an appellate tribunal. So, if this authority or orders is against a person, he can appeal it to an appellate tribunal. Even if after that there is a further processing, there is a process of appeal that we can be done in the Supreme Court, which is the highest body of this appeal. So, if this authority given something wrong, we can go to the appellate tribunal, and then also we can appeal in Supreme Court if we are not okay with the decision of this appellate tribunal. So, then the transfer of data outside India. So, individuals' sensitive personal data may be transported outside for India for processing if they expressly consent and certain extra restrictions are satisfied. On the other hand, such sensitive personal information should continue to be maintained in India. So, sensitive personal information, personal data, it should be stored in the India itself. Even for an overseas condition, overseas companies, they should store the data of Indian personals only in India. That is such a sensitive personal data. So, certain types of personal data identified as vital by the government may be processed entirely in India. So, who actually decides what is sensitive data? It is the government of India. So, such data should be stored only in India and should not be given to the outside India. So, what are the exemptions? The central government may exempt any of the agencies from the act. So, that is one of the loopholes, that one of the power the government can use. For example, there are several security agencies, they want to know about the persons who actually involved in any illicit trafficking or any other activities. So, such kind of persons can be noted with regarding to this exception. So, further the offences. So, if the person, if the companies has actually not abide by this law, is given the privacy, not given privacy for the user, then the bill also provides certain punishment. So, it makes a violation punishable. Re-identification and processing of de-identification personal data without consent carry a maximum sentence of 3 years in prison, a fine, or both. So, if any of the provision is violated, as we discussed before, there will be a maximum sentence of 3 years or a fine or both in some worst cases. So, then will be sharing of the non-personal data with government. The central government may force data fiduciaries to provide the information. So, central government has power to provide, to ask the fiduciary to produce any data to the government. Also, the amendments to other laws. The bill amends the, what are the things which can be amended, which will be amended because of this, the Information Technology Act of 2000 by eliminating provisions that requires firms to pay people when personal data is not properly protected against the disclosure. So, that is all with regarding to this LU. We have seen about the General Data Protection Regulations, GDPR, and we have seen what is GDPR and why the data is very much important in current day sense, and we have also discussed why GDPR is in news regarding WhatsApp privacy policy, and we have also seen about the background of GDPR, how it evolved in European Union, and on the same line how the data protection principles, what are the data protection principles such as the transparency, accountability under GDPR. We have also seen about the data protection laws in line of GDPR in India. So, that is all with regarding to today's LU. Thank you.